In this video, we're going to talk about direct examinations. Let's get into it. Hey everyone, welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. So in this video, we're going to talk a bit about direct examinations. What are they? What are the goals? Who does them? All of that kind of stuff. So to begin, a direct examination is when an attorney calls a witness to the stand to provide evidence or provide testimony for their case. After an attorney does a direct examination, then the witness is basically handed over to the other side to do a cross-examination. And then after that, oftentimes there will be what's called a redirect. Now, although it is possible to call a witness that is considered a hostile witness, in other words, a witness whose testimony is anticipated to be more helpful to the other side than to your side, it is usually the case that an attorney is going to be calling a friendly witness for their case. Now, the goal of a direct examination is basically to put a witness onto the witness stand to provide a narrative that is not just informative, but also understandable and reasonable and ultimately, hopefully, persuasive to the jury that is going to ultimately help to achieve certain boxes that you have to check in order to prove your case. Now, every lawsuit has a cause of action that if you are on the plaintiff side, for example, you have certain elements that you have to meet in order to be successful in your case. If you are the defense, you are trying to prevent the other side from meeting those elements. Now, in a direct examination, unlike a cross-examination, a direct examination is supposed to have non-leading questions. In other words, the attorney is not supposed to look like the spotlight is all on them. They are not supposed to be leading the witness down a particular path by asking questions that sort of presuppose the answer. In other words, they're not supposed to ask questions that would be leading to the witness saying yes or no. Rather, the attorney wants to be asking open-ended questions, questions like the who, what, when, where, how, and why. And there are several reasons for this. Number one is that the presupposition here is that by calling this witness, most likely it's going to be a friendly witness to their case. And so they want to be able to get that testimony through the witness as opposed to the attorney, because it's going to be a little bit more trustworthy. Or at least the testimony should be more trustworthy if it's coming out of the witness. And if the attorney is leading the witness through the testimony, then it will look like basically there's been an over preparation and maybe this witness is not exactly trusted to testify to the truth, but rather to a very specific narrative that would be more beneficial but less accurate. But even from the perspective of the attorney, you want your testimony to be coming more out of the witness than out of yourself anyway, because the jury is likely to trust that testimony a bit more and give it greater weight if it's coming out of the witness's mouth as opposed to out of your mouth. The jury knows that the attorney is one of the main hired guns in the room, and so the witness is likely to have a bit more credibility as to the facts than the same information coming out of someone who they know is a hired gun. Now, when it comes to a direct examination, it's relatively easy to do a direct examination that's going to be mildly competent, but it's actually a bit more difficult to do one that is a stellar direct examination. And this is especially true when it comes to expert witnesses, because they can be very intelligent and very understanding of their field and not necessarily understand how to explain their information and their testimony in a way that the jury will understand. So basically, when you're looking at a direct examination, the competency level of the attorney has pretty much three different goals. The most basic goal for a competent direct examination is just to get the information out of the witness. The second tiered goal of a direct examination is to get that information out of the witness to be understood by the jury. And finally, the top tier of a direct examination is to not just have it be out in front of the jury, not just be understood, but to have that information also be persuasive to that jury. Now, the basic information can usually be drawn out with questions like the who, what, when, and where. Having that testimony be understood by the jury can oftentimes be drawn out through the questions how and why. And the persuasiveness of that witness's testimony is basically going to come down to two main factors. The first is how the attorney is able to present the witness in the best possible light. And the second factor is the extent to which the attorney is able to have the witness present the facts in the best possible light. Now, some witnesses will come across as more genuine or trustworthy than others. You can have a witness that no matter what they say about the uh, geography of Los Angeles in California, that the way that they come across is somehow sketchy. So when you have those two different types of witnesses, that might change the way in which an attorney will approach their direct examination. As an example, a witness that is a little bit less trustworthy inherently in their appearance or the way that they come across to a jury might get questions that are a little bit on a bit of a tighter leash. For example, they might get questions like, what day did you arrive? What was the temperature when you arrived? What color was the car? That kind of thing. But witnesses that the attorney anticipates are likely to come across as more trustworthy, come across as more charismatic or connecting with the jury, that the jury basically is more likely to accept their testimony, can be given a bit of a longer leash or more space to roam, so to speak. So the attorney might ask them questions like, what did you do next? Or did you hear anything after that? Now, considering all of that in the Johnny Depp versus Amber Heard defamation trial, the amount of space that Johnny Depp had in his direct examination to really, really loop around quite a bit as much as he did and to ultimately answer the question that he was asked showed that he had a lot of trust from his counsel. And part of that could be because of the amount of time that he has spent with his counsel and the amount of times that they have prepared for his direct examination. But ultimately, like that is the one thing that a viewer of his direct examination really should come away with more than anything else is the amount of space and the amount of trust that there was in him and that he also had likewise in his attorney. But other than that, can you think of any direct examinations that you have seen, perhaps in the Johnny Depp versus Amber Heard defamation trial, that you found to be particularly compelling? Let us know in the comments down below. Otherwise, if you haven't seen it already, we are also releasing, along with this video, a video on cross-examination. So be sure to check that out as well, linked somewhere in this video or in the description below. Otherwise, I hope you found this interesting or at least informative. And if you did, we would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you haven't done so already, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next video.